Yes, 22nd June 2020. And if you hakilde idre, what do you mean? What is what is the name of the petitioner? Saddam Hussein first bail petition, criminal petition 2693 of 2020, disposed on 22nd June 2020. Again, my order, 17th November 2020.
2019 and one.
Yes, 2019 ಅಲ್ಲಿ ಅದು ಇವರು ಮೊಹಮ್ಮದ್ ಸಿದ್ದಿಕ್ ಇದೆಯಾ ಮೂರು ಟೋಟಲಿ ತ್ರೀ ಟೈಮ್ಸ್ ಬೇಲ್ ರಿಜೆಕ್ಟೆಡ್. ಓಕೆ, this is fourth attempt by the petitioner to come out of jail. His first application for bail before this court was dismissed. First application for bail, criminal petition 2693 of 2020 was dismissed on 22nd June 2020. Second application, that is criminal petition 54. Justice Pandindra Damela. 21/19 ಅಲ್ಲ
which is dismissed for non-prosecution.
First application of the first application for bail, that is criminal petition 6682 of 19 was dismissed for non-prosecution on 21/11/19. Second application 2693 of 20. Third application, petition 5430 of 2020 was dismissed on 17th November 2020. Stop. The petitioner is facing trial in relation to offences punishable under sections 397, 302, 201, read with 34 IPC. Full stop. What's your name? Heard? Huh? Heard Manoj SN, learned counsel for the petitioner. Sri Mahesh Shetty, learned government leader. Full stop. The prosecution case in simple is that on 8/7/19, in between 9:12 and 9:15 p.m. the petitioner caused the death of one Nananda Reddy while committing robbery. Stop. Sri Manoj SN submits that one is the only eyewitness. CW 1 to 9 are shown as eyewitnesses, and CW1 has turned hostile. PW1 has turned hostile. Who is? PW1, who is CW2, has turned hostile. Other witnesses, the prosecution has not been able to secure other witnesses. The petitioner has been in jail for the last 3 years. Therefore, he may be released on bail by subjecting him to any stringent condition. It's per. So Mahesh Shetty opposes the petition, submitting that there are CW 6 to 9 are the direct witnesses. KB is held. Merely because one witness has turned hostile, it doesn't mean that the other witnesses will also turn hostile. Trial is going on. This court has the petitioner is not entitled released on bail. Next para. After hearing both sides, it may be stated that merely because one witness has turned hostile, it doesn't give right to the petitioner to claim bail. Full stop. By disposing of the earlier bail petitions, it is clearly held that prima facie materials are forthcoming against the petitioner. Stop. I don't find a change circumstance at this stage to admit the petitioner to bail. Full stop. Hostility of one witness cannot be considered. Therefore, application petition is dismissed. No direction. Yes. Process, you have to pay process in your case. You take particular tunnel. Sri Dilraj Jude Rohit takes notice for Vishnu respondent. Oh, yes. State is for R1. Or you take notice for R2 and R3. Dilraj Jude Rohit Sequeria takes notice for R2 and R3 in criminal appeal 954 of 16. Tenderly, you your name is there in the connected appeal. Okay, it's recorded. ಇವಾಗ ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡ್ಬೇಕು? ವೇಟ್ ಮಾಡಿ, ಇದೆಲ್ಲ ಮುಗಿಸ್ತೀನಿ. ಇವತ್ತೇ ಮಾಡ್ತೀರಾ? ಅಲ್ಲ, are you ready to argue today? Okay, Monday. This list on Monday. Next. Yet to for recalling the order dated. Manjunath. Year 2 of 22 is filed for recalling the order dated 21st October 2022. First time ಬರ್ತಾರೋದಾ? Petitioner's counsel is absent today. It's next week. Fresh matter. Notice ಹೋಗ್ಬೇಕಾ? The appellant's ಹೋಗ್ಬೇಕಾ ಏನು? Appellant's counsel is present. Issue notice to respond number 2 through IO, concerned IO. Full stop. List next week if service on R2 is completed. Notice, huh?
Yes, sir.
Yes. Yes, notice on R2, what happened? Third. Yes. Huh? Anjan Kumar PN for R2. Yes. Hmm. Hmm. Ah. ನಮ್ಗ ದೇವರಾಜ ಆಯ್ತಲ್ಲ ಕ್ಲಿಯರ್ ಕೇಸ್ ಆಫ್ ಕ್ಯಾಸ್ಟ್ ಅಟ್ಯಾಕ್ ಇದೆಯಲ್ಲ was not allowed to play because he belonged to a particular caste. ಇದೆಲ್ಲ ಎಲ್ರಿಗೂ ಗೊತ್ತಾಗತ್ತೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. See, their reading of the complaint gives an indication that boy was not allowed to play there because he belonged to a particular caste. A clear case of atrocity. Yes. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. ಕೇಸ್ ಫಾರ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್. ಯಾರು ಅಕ್ಯೂಸ್ಡ್? 25 years. A boy, still a boy. But no case. No case. This is an appeal filed under section 14A2 of SC/ST Prevention of Atrocities Act. The appellant has challenged the order dated the 30th September 2022, passed by the second additional district and session judge Chitradurga in criminal miscellaneous number 1053 of 2022. Expire. Heard. 3S or Shashidhar learned counsel for the appellant. Forum reader for respond number 1. Respond number 2 has been served and the counsel for R2 is absent. Expire. FIR was registered 15/9/2022 at 9:30 p.m. in relation to an incident dated 14/9/2022. Full stop. The allegation is that the second respondent went to the playground of the high school. Come on. When the son of the second respondent went to playground of the high school of the village, the appellant herein and another accused, namely Abhishek, did not allow him to play. First up, it is alleged that because the respondent's son, now caste Naika antana, belong to Naika community. Come on. The appellant and this another accused said that he should not play there. So there is another allegation that both the appellant and another accused assaulted second respondent's son severely. As a result, he sustained injury on injury and then threatened to kill him. Next para. But counsel for the appellant submits that the false complaint came to be lodged because of political rivalry. And a counter complaint was also counter complaint air. And the mother of the appellant also made a complaint to the police against the second respondent's son. It is view the allegations leveled against the appellant can be doubted. Therefore, the apprehension expressed by the appellant of being arrested is well founded. Anticipatory bail can be granted. Mr. Sri Mahesh Shetty, learned government leader, submits that given a plain reading to the complaint. Come on, casteist attack is very much forthcoming. Best better. In this view, the court below is justified in declining anticipatory bail. Next para. I have perused the impugned order and also the FIR. The FIR discloses that the second respondent's son was not allowed to play in the playground. Only in the background of the caste factor. Political rivalry is just a defense projected by the appellant at this stage. Requires investigation. At this stage, no inference can be drawn that false complaint came to be registered against the appellant. In the background of political rivalry. Stop. It requires investigation. Section 18 of SC/ST Prevention of Atrocities Act is very much applicable to a circumstance like this. The court below is justified in rejecting the application. I don't find any merit in this appeal, therefore it's dismissed.
My lord, I appeal for the respondent number 2, my lord.
Yes. Yes. Conviction for 15 years. Plant.
Brought to the doctor before the doctor on 23/2019. The allegation of the victim here committed rape during the assistance.
Who took the girl to the hospital?
Police.
Police.
See, then allegation that rape on 28/3/2019. Then they brought to doctor, to the doctor for examination. Before the doctor, she made an allegation that my mother-in-law is committed this rape. 3 days prior to that, people brought to doctor. And statement was recorded by the doctor, saying that in the 1 year prior to the examination, father also raped. This result of examination was allegation that result. On that basis, the child was given to child welfare committee for inquiry. And child welfare committee was statement. The statement not in the year 2019, the father had committed rape, and subsequently the brother-in-law victim was child. On the basis of that statement, the Patriola police on 5/19. It is the father. First thing is on the basis of this incident, as alleged in the complaint, was separate.
It's the father.
And after 164 statement,
What is the age of the girl?
17 years now, as soon as the date.
ಇದು ಸುಳ್ಳು ದೂರನ್ನು ದಾಖಲಿಸಿರುತ್ತೀನಿ ಮಿಸ್ಟರ್
Please, Lord, please.
ಮಿಸ್ಟರ್ ಪ್ರತೀಕ್.
Lord, I'm sorry, sir. I'm sorry.
ಇದು ಸುಳ್ಳು ಫಸ್ಟ್ ಒನ್ ಸುಳ್ಳು ದೂರನ್ನು ದಾಖಲಿಸಿರುತ್ತೆ. ದಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಬ್ರದರ್ ಇನ್ ಲಾ. That is second one is against father. One, two. ಇದು one. ನಾನು ಮತ್ತು ನನ್ನ ಭಾವ ತಂದೆ ಮೇಲೆ ಸುಳ್ಳು ಫಿರ್ಯಾದಿ
Cross-examination, she is narrating the reasons. On the same day, the cross-examination was done. The cross-examination, she explains the reason for filing the complaint, totally denying the allegation.
It is marked exhibit P3. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನ್ ಹೇಳುತ್ತೆ? ಹಿಸ್ಟ್ರಿ ಅಲ್ಲ, ಡಾಕ್ಟರ್ಸ್ ಅಬ್ಸರ್ವೇಷನ್.
It is prior to that application in that matter is prior. ನಾನು ಇವತ್ತು ಮೊದಲು ಮಾಡಿದ್ದೆ ಬಟ್ ಮಾಡಿದ್ದೀನಿ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್
Siri, para 11 होती. Please read para 11.
Narrates the child welfare committee counselor stating that it had taken to the Lord and
ನಾನು 9ನೇ ತರಗತಿಯಲ್ಲಿ ನನ್ನ ತಂದೆ ನಾನು ಒಳ್ಳೆಯ ಪದಾರ್ಥ ಜ್ಯೂಸ್ ಅಲ್ಲಿ ಅಮಲು ಪದಾರ್ಥ ಹಾಕಿ ಲೈಂಗಿಕವಾಗಿ ಸಂಪರ್ಕಕ್ಕೆ ಬಳಸಿಕೊಂಡಿದ್ದಾರೆ.
the statement of the child welfare committee.
But further in paragraph 50,
That was people and the evidence.
ನಮ್ಮ ಭಾವ ಪಥಕ್ ವಿರುದ್ಧ ಉಳ್ಳಾಳ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕೊಟ್ಟಿದ್ದ ಕಂಪ್ಲೇಂಟ್ ಸಂಬಂಧ ವಿಚಾರಣೆ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ.
the part received and the witnesses.
ಈಗಲೂ ಸಹ ಆರೋಪಿಯ ನಮಗೆ ಜೀವನಾಧಾರವಾಗಿದ್ದು master. Yes. This could be the reason for the girl going out taking a contrary stand contrary to the prosecution.
In the beginning, narrated by CR and the allegation of rape, brother-in-law or prior to immediately prior to the medical examination conducted after immediate with regard to the allegation of brother-in-law. And myself terminating marriage of and I was on bail during the trial.
Were you on bail?
Yes,
ಆತರ ಇಲ್ವಲ್ಲ, ಡೇಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಆಫ್
I was on bail.
8/4/19. ಬಟ್ ಇಲ್ಲಿ ತೋರಿಸಿ ಡೇಟ್ ಆಫ್ ರಿಲೀಸ್ ತೋರಿಸಿಲ್ಲ.
You are on bail.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ? ಬರ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ನೋಡಿ. ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ. A1 of 22 will be considered after receipt of trial court records. Four 38. ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ವಿರೂಪಾಕ್ಷಪುರ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಲಾಯರ್ ಲಿಂಗಪ್ಪ, ಹಾ, ಇಲ್ಲಿ MK ನಿಂಗಪ್ಪ ಅಂತಿದೆಯಲ್ಲ. ಹ್ಮ್. ಆ ಮರಗಳು ಯಾರ್ದದು? ಇವಾಗ ಅವ್ರ ಜಮೀನಲ್ಲಿ ಮರ ಇದ್ರೆ ನೀವು ಕಡಿಯೋದು ತಪ್ಪಲ್ವಾ? Complainant says that the teak trees were grown by him in his land. ಎರಡು ತೇಗದ ಮರಗಳನ್ನು ಕಡಿಯುತ್ತಿರೋ ಶಬ್ದ ಕೇಳಿ. ಇವೆಲ್ಲ ಬಿಟ್ಬಿಡಿ, ಅದೇನು ಬೇರೆ ಯಾರ್ದೆಲ್ಲ ಬಿಡಿ. ಹಾ, ಇದು ಅವ್ರ ಜಮೀನ್ಗೆ ಹೋಗೋದು, ಮರ ಅವಂದಾದ್ರೆ ಕಡಿಯೋದೆಲ್ಲ ತಪ್ಪಲ್ವಾ?
It refers to only. Predominantly on the ground level. Yes, sir. And I have been indicating.
ಇಲ್ಲಿ ಹೆಸರು ಇಲ್ವಲ್ಲ, ಅಲ್ಲಿರೋದು ಲಿಂಗಪ್ಪ ಅಂತ. ನೀವೇ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಾ? ಇರಿ, ಲೆಟ್ ಮಿ ಆಸ್ಕ್, whom do you arrest in case? ಅಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮೇಲೆ ಇದು ಸರಿ. ನೀವು ಆಕ್ಷನ್ ತಗೊಳ್ಳೋದಾದ್ರೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ, ಈ FIR ಮೇಲೆ, do you go against this advocate? It's a ಲಿಂಗಪ್ಪ, ಲಿಂಗ LI. ಇವರು NI. No, you make it clear. If you are not going to arrest him, it's this person Ningappa is totally different from.
He may be wrong giving it because he also the complaint itself shows that he doesn't know. Somebody had introduced him. He is a lawyer Lingappa. You know, I don't know. Lawyer Lingappa.
He is practicing at Chanpatna, na? ಚನ್ನಪಟ್ಟಣದಲ್ಲಿ ಇದೇ ಹೆಸರಿನವ್ರು ಬೇರೆ ಇದಾರ ಲಾಯರ್ಸ್?
Confusion regarding the name, the citing that was rejected.
On speculating the matter involved in the instant case from the viewpoint of the ignorance. ಲಿಂಗಪ್ಪ ಚಿಕ್ಕ, ನಿಮ್ ಸ್ವಂತ ಊರು ಯಾವುದು? This your you have given your address as 6th Acres, Raja Kempegowda Badavane, Chenpatna town. ಇಲ್ಲಿ ಬರೆದಿರೋದು ಲಾಯರ್ ಲಿಂಗಪ್ಪ, ಚಿಕ್ಕ ಕಲರೂರೊಡ್ಡಿ ವಿಲೇಜ್, ಕಸ್ಬಾ ಹೋಬಳಿ, ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು. Which is your native place? ಅದು ನೀವು ಇಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರ್ಬೋದು ನೇಟಿವ್ ವಿಲೇಜ್ ಮೊದಲಿಂದ ಅದೇನಾ? ಆರ್ ಯು ಕನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಎ ಹೌಸ್? ಸರಿ, ಮನೆ ಕಟ್ಟಿಸ್ತಾ ಇದ್ದೀರಾ? ಮತ್ತೆ ಅಲಿಗೇಷನ್ಸ್ ನೋಡಿದ್ರೆ ಅವ್ರ ಮನೆ ಕಟ್ಟಿಸ್ತಾ ಇರೋ ಲಾಯರ್ ಲಿಂಗಪ್ಪ ಬಂದು ಮಾಡೋದು. ನೀವು ಮನೆ ಕಟ್ಟಿಸ್ತಾ ಇಲ್ವಲ್ಲ, ನೀವಲ್ಲ ಆಗದು. Lingappa referred to here is one who is constructing a house, but you are not constructing a house. So you need not have a fear of being arrested. You are not the person. You are not the person. How can they arrest you? ಅದೇನ ದಾರಿಲಿ ಹೋಗು ಇವ್ರ ಮನೇಲಿ ಮಾರಿನ್ಗ ಮನೆಗ್ ಬಡ್ದ. ಇವರೇನಾ? ಬೇಕು ಅಂತ ಹಂಗ್ ಬರ್ದಿಯಾರ್ರಿ ನಿಮ್ಗೆ ಹೆಲ್ಪ್ ಆಗ್ಲಿ ಅಂತ. ನೋಡಿ, FIR ನೋಡಿದ್ರೆ ಇಟ್ ಈಸ್ ಎ ಪೊಲೀಸ್ ಲ್ಯಾಂಗ್ವೇಜ್, 100% ಪೊಲೀಸ್ ಲ್ಯಾಂಗ್ವೇಜ್. ಯಾರ್ದು ಡಿಕ್ಟೇಟ್ ಮಾಡಿರೋದು ಯಾರು? ಅಲ್ಲ, ಹಂಗ್ ಬರೆಯಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. ಅನ್ಲೆಸ್ ಪೊಲೀಸ್ ಇಂಟರ್ಫರೆನ್ಸ್ ಇಸ್ ದೇರ್, ಕಂಪ್ಲೇಂಟ್ ಕೆನಾಟ್ ಬಿ ರಿಟನ್ ಲೈಕ್ ದಟ್. ಬರ್ಕೊಳ್ಳಿ. This is an appeal filed under section 14A2 of SC/ST Prevention of Atrocities Act. The appellant is accused number 2 in FIR number 221 of 2022, registered by the first respondent police for the offences under sections 3(1) RS SC/ST section 3(1) RS of SC/ST Prevention of Atrocities Act and sections 427, 506, 504, 447, read with 34 IPC. The appellant's application for anticipatory bail, it is criminal miscellaneous 962 of 2020, was rejected by the First Additional District and Session Judge Ramnagara by order dated 7th November 2022, and therefore this appeal. Next para. But Sri A.P. Chandrasekhar, learned counsel for the appellant, and the government pleader for respond number 1. Respond number 2 has remained absent, has not appeared before this court in spite of service of notice on him. Next para. Perusal of the impugned order shows that the trial court, the court below, appears to have declined anticipatory bail to the appellant because the identity of accused number 2, or there is some confusion with regard to identity of accused number 2. In the FIR, the name is written as lawyer Lingappa, LI, of Chikkaluru Doddi village, Kasba Hobli, Chenpatna Taluk. But the appellant is an advocate. His name is M.K. Ningappa, a practicing advocate at Channapatna town. So next para. In regard to incidents dated 21/9/2022, the second respondent approached the police on 3/10/2022. List of the allegations found in FIR are that the second respondent came to know that two teak trees were being cut. Two teak trees grown by him in his land were being cut at 10 a.m. on 21 date 21/9/2022. Sentence okay.
That incident dated 21/9/2022. Second respondent of the position 3/10/2022. Actions found in FIR are like the second respondent.
Second respondent came to know at about 10 a.m. on 21/9/2022 that two teak trees grown by him in his land were being cut. So he went to that place and saw the trees being cut. He questioned, when he questioned one Mahalinga, he is accused number one, huh? It is accused number one as to why he was cutting the trees. Come on. He showed one Lingappa and said that he wanted trees. Said that Lingappa was constructing a house and he wanted trees. Full stop. When the second respondent told that the trees belonged to him, it is released that the second Lingappa, L.I. Lingappa, took the name of the caste of the second respondent, used him in vulgar language with reference to his caste, and threatened him of dire consequences. Full stop. Next para. Therefore, as has been observed by the trial court, the person present at the place was one Lingappa, not Ningappa. Full stop. But the argument of Sri K.P. Chandrasekhar is that there is only one person by name K.M. Ningappa who is practicing as a lawyer at Channapatna. Full stop. Actually, Lingappa, and for this reason, he has a threat of being arrested. Full stop. He also submits that all IPC offences mentioned in the FIR are bailable. And the allegation with regard to caste cannot be believed because of delay in registration of FIR. Full stop. The government pleader submits that the investigation is still pending and the police have to ascertain whether this appellant was the person who was present at the place or not. Next para. If the appellant is the only advocate practicing Channapatna, in FIR, The name forthcoming is Lingappa, L.I. It's also called lawyer Lingappa. Stop. Appellant's name is K.M. Ningappa, N.I. And he is a practicing advocate. Stop. As per the submission made by Chandrasekhar, appellant is not constructing a house. Are you sure? Not constructing any house. If this submission is taken into consideration, an inference may be drawn that it was not the appellant was present at the place of incident. Stop. However, appellant apprehension of being arrested appears to be well founded because at Chenpatna there is no other person by name Ningappa. There is no other practicing advocate by name Ningappa. Stop. Therefore, Lingappa, as referred to in FIR, according to him, is he only, refers to him, and for this reason, he expresses a fear of being arrested. Stop. Next para. Anticipatory bail can be granted not in favor of a person who has threat of being arrested in connection with a non-bailable offense. Full stop. In view of some confusion in the names, if the appellant has the fear of being arrested, it can be taken into consideration. Full stop. It has been argued by the appellant's counsel. The offences punishable under 447, 427, 506 and 504 are bailable. And only non-bailable offence is under section 31R of SC/ST Prevention of Atrocities Act. Stop. If appellant was the person who was present at this spot while cutting the trees, the delay in registration of FIR certainly matters. So it's not understandable as to why second respondent waited till 3/10/2022 for approaching the police, even though the incident is said to have taken place on 21/9/2022, has no explanation. Full stop. In this view, I find that appellant has made out a case for grant of anticipatory bail. The trial court, the court below could have allowed the application, having could have granted anticipatory bail in these set of circumstances. Delay in registration of FIR is sufficient enough to come to conclusion that there is no prima facie case got to commission of offence under section 31R of SC/ST Prevention of Atrocities Act. And thereby section 18 is not applicable. Therefore, appeal is allowed. 50,000 one surety in the event of arrest. Yes. ಇಲ್ಲ ಆ ಥರ ಅದು ಹಾಕ್ಬೇಡಿ. 307. 4 years 40,000. ಏನ್ ಇಂಜುರಿ ಏನು? ಎಲ್ಲಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಪ್ಯಾರಾ but inside wound the neck anterior 5 into 1 centimeter. Depth irla 5 centimeter long, 1 centimeter. ಅಷ್ಟೇ cut inside wound neck anterior aspect. What is her opinion? Doctor's opinion. Why did he inflict injury on the neck? Accused. Bail ಮೇಲೆ ರಿಲೀಸ್ ಆಗಿಲ್ವಾ? ಟ್ರಯಲ್ ಇದ್ದಾರೆ. ಎಸ್ ಬರ್ಕೊಳ್ಳಿ. Appeal is heard. ಸೋಮಶೇಖರ ನೀವು ಹೆಸರು heard Sri Lakshmikant, advocate for the appellant. Appeal is admitted. Next para. IA 1 of 22 is filed seeking suspension of sentence. So the appellant is sentenced to simple imprisonment for 4 years and fine of rupees 40,000 with default imprisonment for 1 year for the offense under section 307 IPC. He stated the appellant was on bail during trial. According to the appellant, all the material witnesses turned hostile. Medical evidence shows that the injuries were simple in nature. This view, judgment of conviction needs to be examined. But at this stage, there is no impediment for suspending the sentence. Hence, application is allowed. First, 1 lakh 2 sureties. Yes. $323. Sentence to fine about $323 for a period of 3 years and for 354B. Yeah, why not? 106. ಆಯ್ತು ಬೇಡ ಅಂತ ಬರ್ಕೊಡಿ. Appellant's counsel appeal is admitted. Same ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Appellants ಮಾಡಿ. Appellants are sentenced. Each of the appellants is sentenced to fine of rupees 1,000 with default imprisonment for 1 month in relation to offence of 323, rigorous imprisonment for a period of 3 years and fine of rupees 3,000 with default imprisonment for 2 months in relation to offence under section 354B IPC, rigorous imprisonment for 1 year for the offence 504, rigorous imprisonment for 1 year for the offence in section 506, and rigorous imprisonment for 3 years and fine of rupees 1,000. Default imprisonment for the offence under section 31 RSW of SCST Prevention of Atrocity Act. Stop. All the appellants were on bail during trial, and even after pronouncing sentence, they were so the sentence was suspended. The trial court for a limited time enable them to prefer an appeal. Stop. In this view, substantive substantive sentence of imprisonment both on the appellants is suspended. Each of them 50,000 one surety. Fine amount to be deposited within 2 weeks. Call for records allow.
ನಾಯಕ್ ವೆಂಕಟನಾಗಪ್ಪ
5 years under 7. I notice of Burley. Appeal is admitted. Heard appellant's counsel appeal is admitted. Issue notice to respondent. 5 ವರ್ಷ ಇದೆ ರೀ. ಸರಿ ಸಾಕು ಬರ್ಲಿ. List after 10 days if service is completed.
Very good.
W. ಪ್ರಕರಣದ ಗಂಗರಾಜು ಮಾಡಿಸುವಡಿ ಹಾ Gangaraju, who is Gangaraju? ಅಷ್ಟೇನಾ? Victim is Manasa. ಏನ್ offense? What are the offenses? 302. Who? All right, yes. Now service is on 3CW. Manasa is CW4, huh? 2. ಏನ್ ಕೇಸ್ ಏನು? ಏನಿದೆ ಗ್ರೌಂಡ್? Your conscience is a witness. Eyewitness ilda. Human eyewitnesses are not there. Question your conscience. Is it not a witness? Huh? Unfortunately, ಎಲ್ಲ ನಾವು eyewitnesses ಇಲ್ಲ ಹಾಗೆ ಇದೆ. Eyewitnesses ಇಲ್ವಾ?
He was sleeping in the terrace of the hotel. Earlier, ಹೇಳಿದ ನಂತರ he had taken the body collection. ಮತ್ತೆ he was body.
ಏನಿಲ್ಲ. Terrace Melian is a case of strangulation.
Strangulation.
Then he took the body to another place, poured that, whatever remained in the bottle.
Again, my body was not.
ಹೌದು ವಿಕ್ರಮಾದಿತ್ಯ
In this statement, body was recovered. This is the content is clarification is as well. So for a dispute, the appellant is concerned. For to screen him by this another person here, he was past implication with this.
ಯಾರು who is he to screen somebody who is fool.
According to the prosecution, this lady is for CID given another person.
That is a motive.
But what is concerned, according to they are not concerned matter. Is not the case of the prosecution matter. The witness was the appellant only, and after consequent burden, nothing is there matter. He only came to the terrace matter, and he is insisted for the liquor. This is the only insisted for the liquor. And we have a matter and the what is concerned, my lord, appellant is not what to wait. The thing is there, our department of the national hotel is part of the state and
ಎಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಟ್ರಯಲ್ ಆಗಿಲ್ಲ ಮತ್ತೆ ಮೋಟಿವ್ಗೆ ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಇರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. Dead body was on the terrace.
So they saw, they thought that he stated that she is not well, she is sleeping. Then that's what they did. And he had taken the rickshaw on 2-3. He was applied for 3-3.
ಏನಾಗುತ್ತೆ? PM report ಕೊಟ್ಟು ಅಲ್ಲಿ ಬರ್ದಿರುತ್ತೆ ನೋಡಿ, ವಾಟ್ ವಾಸ್ ಸ್ಟೇಟ್ ಕಂಡೀಷನ್ ಆಫ್ ದಿ ಬಾಡಿ. ಆಯ್ತಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ತೋರಿಸಿ. ಅಲ್ಲಿ ಅಂಗಡಿಗೆ ಹೋಗಿ ತರ್ತಾನಲ್ಲ 2 ಬಾಟ್ಲ್ ವಿಸ್ಕಿ, ಅದಕ್ಕೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ? Everything is there. See, ನಾನು ಸಾಮಾನ್ಯವಾಗಿ ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ ಬೇಲ್ ಕೊಡ್ತೀನಿ, ಧಾರಾಳವಾಗಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಬಟ್ ಈ ಕೇಸಲ್ಲಿ ಕೊಡಕ್ ಆಗಲ್ಲ. ವೆರಿ ರೇರ್ಲಿ ಹ್ಯಾವ್ ನೋಡ್ರಿ, 3 ಸರ್ಕಮ್ ನಾನೇ ಹೇಳ್ತೀನಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು, ಒಂದು ಮೋಟಿವ್, ದಟ್ ವುಮನ್ ವಾಸ್ ಫೌಂಡ್ ಟು ಬಿ ಹ್ಯಾವಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್ ವಿತ್ ಅನದರ್. ಸೊ ದಿಸ್ ಇದಕ್ಕೆ he became fury. Is accused. Reason is this: he was having relationship with that woman. He came to know that she was having relation with another man. Because of that, he developed some kind of intention, intention to kill her. Then On that night, she came there. She wanted liquor. He goes to a shop and buys 2 bottles of wine. Wine or lay. She drank it. When she was sleeping, so 2 circumstances are over. Second one, the third one is burning the body. It was not completely burned. Again, he brought the body to the terrace, covered the body. A hotel owner ಕೇಳಿದಾಗ he said that she was not well. He carried the dead body. By that time, she was dead. ಹೌದು ಹೌದು ಅದೇ ಹೇಳೋದು. ನಾನೇನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಓದೋ ಅಗತ್ಯನೇ ಇಲ್ಲ. ಐ ಕ್ಯಾನ್ ಇಮ್ಯಾಜಿನ್. ಎಲ್ಲಪ್ಪ ಅಂತ ಕೇಳ್ತಾನೆ ಅಷ್ಟೇ. ಜ್ವರ ಬಂದಿದೆ ಅಂತ ಹೇಳಿದಾನೆ ಅಷ್ಟೇ ನೋಡಿ. ಅದೇ ಅಷ್ಟೇ. ಅಷ್ಟೇ. ಆ ಒಂದ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾ? ಯಾರು ನಿಮ್ಗೆ ಹೇಳ್ಬೇಕು. ಯು ನೋ ದಿ ಪರ್ಸನ್. ಯಾರ ಚಿಂದಿ ಆಯುವ ಹುಡುಗ ಅಂತ. You might have seen. Show him. They will examine. Quality statement ಇದೆಯಾ? ವಾಲಂಟಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಂದ ಮಾಡ್ಕೋಬೋದಿತ್ತಲ್ಲ ಅವ್ರನ್ನ ಕರೆದು ಮಾಡಿ. ಇವಾಗ ಅವ್ನ್ ಕರೆದು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರೆ ಅವ್ನು ಹೇಳೋದು ನಾನು ಇಲ್ಲ, ಸಂಬಂಧ ಇಲ್ಲ ಅಂತಾನೆ ಅವ್ನು ಹೇಳೋದು. ನೋಬಡಿ ಅಡ್ಮಿಟ್ಸ್. ಅಷ್ಟೇ ನೋಡಿ.
ಯಾರು
Your thumb impression is also taken. ವಾಲಂಟಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳೋದೇ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್. ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೋಪದಿಂದ ಅಂತಿದೆ ಅಷ್ಟೇ. ಮಿಟಿಗೇಟಿಂಗ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ನಾಟ್ 4 ತರ್ಬೇಕು ನೋಡ್ಬೇಕು. ಮಾತು ಬೆಳೆದು ಬೈದಾಡಿಕೊಂಡು ಕೋಪದಲ್ಲಿ ಟೆರೇಸ್ ಮೇಲೆ ಸಡನ್ ಪ್ರೊವೊಕೇಶನ್. ನೀವು ಹಿಂಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕ್ರಿ, ಮಾಡಿಲ್ಲ ಅಂತ ಹೋಗು ಯಾವತ್ತಿಗೂ ಮಾಡೋ ಹಂಗೆ. ಚಾರ್ಜ್ ಶೀಟ್ ನ ಕರೆಕ್ಟ್ ಆಗಿ ಓದ್ರೆ ನಿಮ್ಗೆ ಸಿಕ್ಕತ್ತಪ್ಪ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ. ವಾಲಂಟ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ನಿಮ್ಗೆ ಬೇಕಾಗಿರೋದು ಅಲ್ಲಿದೆ. ಇದೆಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು ನೀವು ಮಾಮೂಲಿಯಾಗಿ ಮಾಡಿಲ್ಲ ಹಾಗೆ ಹೀಗೆ ಅಂತ, ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ವೇ ಆಫ್ ಆರ್ಗ್ಯೂಯಿಂಗ್. ಓದ್ತಾ ಇದ್ರೆ ನಾನು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಯಾವತ್ತೂ ಇರೋದನ್ನೇ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ, ಅಲ್ಲೇ ಸಿಕ್ಕತ್ತೆ ನಿಮ್ಗೆ ಬೇಕಾಗಿರೋ ಮೆಟೀರಿಯಲ್ಸ್. ಡೋಂಟ್ ಟ್ವಿಸ್ಟ್. ಕೇಸಿಗೆ ಬೇರೆ ಬಣ್ಣ ಬಳಿಬೇಡಿ ದಯವಿಟ್ಟು. ಇರೋದ್ರಲ್ಲೇ ಹುಡುಕಿ, ಸಿವಿಲ್ ಆಗ್ಲಿ ಕ್ರಿಮಿನಲ್ ಆಗ್ಲಿ. ಸಿವಿಲ್ ಕೇಸ್ಗಳಲ್ಲಿ ಹಾಳು ಮಾಡ್ತಾರೆ. ಹೇಳೋದೇ ಒಂದು ಕಕ್ಷಿದಾರ, ನೀವು ಬರೆಯೋದೇ ಒಂದು. ಕೇಸ್ ಇಸ್ ಸ್ಪಾಯ್ಲ್ಡ್. ಅವನೇನ್ ಹೇಳ್ತಾನೋ ಅದನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ. This is an appeal under section 14A2 of SC/ST Prevention of Atrocities Act. First up, the appellant being the accused. By number 206 of 2022 registered by the respondent police. First respondent police. Applied for bail under section 439 CRPC. And since by order dated, where is the impugned order? 3rd August 2022. Dismiss the appellant's petition, miscellaneous 8151 of 2022. The appellant has preferred this appeal. Stop. Next para. Third Sri Umesh. Current counsel. You argued on behalf of Prakash, huh? Current counsel who appeared, who argued on behalf of Prakash KV, Kamal, learned counsel for the appellant, and a government pleader for respondent number 1 and 2. Stop. Respondent number 3 is the complainant, huh? Is daughter of victim, daughter of deceased, daughter of the deceased. Stop. The notice of this appeal was served on her brother.
Brother of the deceased.
When notice was ordered to the respondent, it was served on the brother of the deceased. Thereby there is complaints of thereby Respondent number 3 is duly notified. Step. Nobody has appeared on behalf of respondent number 3. Respondent number 4 ಮಾಡಿ ನೋಡ್ರಿ 4 ಮಾಡ್ರಿ ಅದನ್ನ. Actually, respondent number 3, Manasa was brought on record in the place of Sri Gangaraju, who was earlier made a party as he was the first informant. First informant tane Gangaraju, as he was the first informant. Next para. The charge sheet has been filed for the offences under section 302, 201 IPC and section 325, 5A of SC/ST Prevention of Atrocities Act. Stop. The matter, the CW1 Gangaraju made a report to the police about the incident of homicidal death of a woman by name in ಹೆಸರು Pushpalata. Stop. The prosecution case is that appellant was having illicit relationship with the deceased Pushpalata. Stop. Later point of time, appellant came to know that the deceased was also having relationship with another man, and this irked him. Stop. He was working in a hotel. First sentence in purpose. Appellant was working in a hotel. This irked him ಆದ್ಮೇಲೆ ತಗೊಳ್ಳಿ. On 28/2/2022, a hotel belonging to CW10 ಮಾಡಿ. CW10 is a hotel owner ಅಲ್ವಾ? Appellant was working in a hotel belonging to CW10. Krishna. CW10 Krishna. On 28/2/2022, appellant finished his hotel work. Come on. Went to a wine shop and had liquor and food. Full stop. He came back to hotel building and slept on the terrace at 9:30 p.m. Full stop. 5 or 6 minutes later, the deceased came to that place and she asked the appellant to bring liquor for her. Stop. Appellant went to wine shop again and bought 2 bottles of liquor. Stop. When the deceased was drinking liquor, appellant questioned her regarding the illicit relationship she was having with another man, and this led to a quarrel between them. Stop. And when the appellant was sleeping, when the deceased was sleeping, The appellant is said to have strangled her. Stop. Finding the deceased dead, he carried the dead body on his shoulders to a vacant place nearby and tried to burn it. As the body was not completely burnt, he brought the body again on his shoulders, kept it on the shoulders, covered it with a blanket and kept it on the hotel terrace. So when the hotel owner asked about the deceased, he told him that she was unwell and not able to walk there. Full stop. Saying so, he carried the dead body in his shoulders to a hut where they were living earlier. And left it there itself, left the dead body there itself. Full stop. Next para. As argued by the trial court, learned appellant's counsel, there are no eyewitnesses. The case is based on circumstantial evidence. So the trial court is of the opinion that there are materials prima facie indicative of the involvement of the appellant. Start. But the impugned order is not sustainable because the trial court appears to have not assessed the charge sheet materials in proper perspective. Stop. Firstly, with regard to registration of FIR for the offence under section 325 and 5A of SC/ST Prevention of Atrocities Act, there are no materials at all. Stop. Merely for the reason that the disease happened to be only firstly Ananda in this trial court. Adalli ಒಂದು ಪ್ಯಾರ ಮಾಡಬೇಕು. Mention sentence not.
ಅಲ್ಲಿಂದ ಪ್ಯಾರ ಸರ್.
Last time.
Registration of software for the offense under Caste Act, there are no materials at all.
No materials at all. So merely for the reason that disease happened to be scheduled caste. The offense under the Atrocities Act has been invoked. So according to charge sheet itself, motive is not the caste factor, but is a suspected illicit relationship between the deceased and another man. Stop. Secondly, in relation to offences under section 302, relation to offence under 302, it is possible to make out at this stage from the voluntary statements of the appellant itself that the appellant resorted to killing the deceased in a fit of anger during quarrel. Full stop. Though it is possible to make out that the appellant had a grudge against the deceased because of her relationship with another man. Come on. It is not forthcoming whether he really intended to eliminate the deceased for this reason. Stop. Voluntary statement is a part of charge sheet, which can very well be considered for assessing the materials, assessing the existence of prima facie case. Full stop. The charge sheet does not indicate, or has not cited the person with whom the charge, the prosecutor does in the charge sheet, or in the charge sheet, the person with whom the deceased was said to be having illicit relationship is not cited as a witness. The motive is forthcoming in the voluntary statement itself, and it was illicit relationship between the deceased and another man. So therefore, if entire circumstances are analyzed, at this stage it is possible to arrive at a conclusion whether an offence punishable in section 302 IPC is really made out or not. Therefore, existence of prima facie materials for the major offence of 302 are not forthcoming. Hence, the impugned order can be set aside for admitting the appellant to bail. In this view, following order, appeal is allowed. 2 lakh 2 sureties. Till conclusion of trial, he must mark attendance once in a week before the concerned police station. He shall not leave the jurisdiction of the trial court without prior permission. Last para. The trial court shall, while deciding the case on merits, the trial court shall not be influenced by any of the observations made in this order, and it may take independent decision based on the evidence.